everyone. Welcome back to another episode of the Divorce and Separation Coach podcast. Today, we're going to be talking about the ins and outs of family mediation, how it works, what to expect, but especially how to prepare. Now, I've noticed in my practice that there's more and more awareness about family mediation and how it can help in the context of a divorce, which is great. But people are often unclear about how exactly it works. And that's probably normal because they've never been through family mediation before. So to talk us through the detail of the process and how it usually unfolds, I've invited Katy Harris, who is a qualified family mediator and civil mediator. She's the owner of Mediation Matters Midlands, and she covers the whole of the UK. And Katy promotes mediation as an alternative dispute resolution mechanism, and she brings a huge amount of energy to how she works with her. And she brings a huge amount of energy, knowledge, and compassion to her practice. What I love about Katy is that she wholly believes in the opportunities that mediation offers, and she understands that it allows her clients to remain in control of their decisions, to reduce conflict, and to move forward with their lives. And most importantly, to avoid unnecessary, stressful, and expensive litigation. So, Katy, welcome. Thank you for joining us.
Thank you for having me. Hi.
So, can we start with the basics, I guess? In what cases would you use family mediation? Are there times where it's not appropriate?
When would we use it? We would use it in really any case with family disputes. So where a couple are separating at the end of a marriage or at the end of a relationship, where there is any dispute around money or children. And when can it not be used?
Yeah.
There are cases where it can't be used, but in the majority of cases now, the way that we manage mediation, we can do online mediation, we can limit risks to anybody. There's fewer cases where mediation is no longer appropriate.
Okay. So the first step actually to assess that, right, is a MIAM. Could you talk us through what a MIAM is and how it usually works?
Yeah. So a MIAM is the first step, as you just said, into the mediation arena. And MIAM is a separate meeting, a one-to-one meeting for each person to attend with the mediator. So MIAM actually stands for Mediation Information Assessment Meeting.
Yeah.
And essentially that's what it is. It's a mediation information, so giving you information on the mediation arena, assessing for the suitability of mediation for both the mediator and the client.
Yeah.
Providing the opportunities and options of alternative ways to resolve issues. So the
Yeah.
courts, solicitors, mediation, even arbitration, all of those need to be considered so that the clients can make an informed decision. And that's what the MIAM is about, really, is informing clients so they can choose, understand what the options are, understand the processes, and make an informed decision on how they wish to move forwards.
Amazing. So that's the only time where you meet the client separately, right? After that, it's all joint.
Yes, in family mediation,
Yeah.
we would normally work with the clients together. Everything should be transparent after the assessment meeting. So we would have the initial assessment meetings with each of the clients, and then if everyone's in agreement that mediation should proceed, we would bring them into the same shared space where those communications can start. Although we bring them into the same space, we talk about the space being the mediation arena.
Yeah.
Not a physical space, often online, but also we do facilitate a lot of what used to be known as shuttle mediation, but separate space mediation. So
Yeah.
we'll speak with one client online. It'll be in real time, a live meeting, but we'll speak with one client and then we will put them in the waiting room. We'll bring the other client into the virtual room, relay the information from the client, get a response, put that person back in the room, and then bring the other person and relay it. It's a little bit more disjointed, takes a little bit more time and a bit more skill and memory to be able to relay things verbatim. But we do a lot of that as well. And that's one of the reasons why we're able to facilitate most mediations in most cases, because it alleviates issues around if there are non-molestation orders or restrictions or any worries or emotional instabilities, which aren't significant enough to make mediation unsuitable, but might make it unsuitable for it to be with everybody being in the same shared space.
Space is meant loosely. It's the mediation forum, basically.
Yes. Yes.
And so after the MIAM, and once you've assessed the situation and decided yourself and the clients that mediation is the right way forward, what does the process typically look like? I know it varies from one case to the other, but what can people expect in terms of number of sessions, et cetera, and how long it takes, in terms of weeks or months?
Okay. What I want to say to that is it depends how hard the clients want to work, is ultimately the the answer to that question. But I will give you some rough figures so that it's more understandable. So for mediation around all issues, which would be
Yeah.
children and finances, we would normally say to estimate for around 4 sessions. If it is just finance, we'd say 2 to 3 as an
Mhm.
average. Work on worst case scenario, go for 3. And for children's matters only, 1 to 2. So with those, finance, that can be funded by legal aid if parties are eligible for legal aid. At Mediation Matters Midlands, we don't accept legal aid, but there are plenty of mediation companies out there that do, and you can search for those via the Family Mediation Council website, put in your postcode, ask for a mediator, and it will throw everyone up. You can tick a box to show just the legal aid mediators in your area, and it will provide those results. So legal aid is available for people who are eligible for it. That's for finance for children for all cases. And there's also a family mediation voucher available, which is for anyone who is mediating around children's matters. So the Ministry of Justice have put that together to try to prevent the court backlog and encourage people to resolve their own difficulties, because that's really to a co-parenting relationship moving forwards. So it covers up to £500 worth of mediation costs per couple, so per case, per person. And that would normally be accessed by the mediator, would normally apply for that on behalf of the clients. And they would just need to sign a consent order to give permission for the application to be made to be able to cover that cost. That can't cover the cost of the MIAMs. The paid for separately, but it is up to £500 worth of mediation costs.
Okay. Do couples usually split the cost of mediation? Do they each pay for their half, or how does that usually work?
I actually had a client yesterday who questioned this. It's the first time anyone's ever questioned it, and he said, I find it really odd that we pay per person and that your prices are per person. And I explained to him the reason for that is because mediation is an equal process. And part of my job as a mediator is to ensure that each person is equally committed and is equally paying and is treated equally and fairly. That's not to say that there aren't occasions where one party might pay for the other, where we've got one person who is employed or a higher earner, one person who's unemployed or on benefits or on a lower income. Then they may distribute the costs differently, but there's a working assumption that each person will pay their own costs and equally split everything to ensure we've got that balanced process.
Okay. I mean, with regards to how long the process takes, I guess there's an element as well of how prepared people are and how much documentation they have ahead of the sessions. Is there anything that they can do to prepare for mediation, make the most of that time they have with you?
For any mediation, the best thing for them to do is be prepared to move from their position and be prepared to negotiate. Or from a more practical point of view, in what can we do paperwork wise, etc., that would really only apply to finance cases, really, or all issues cases where people would need to prepare their financial information. So it doesn't necessarily mean that they need to get everything together and work out what they need, because we can walk them through that process and handhold them, as I say, so that they know what to do. But things like pension values, so cash equivalent transfer and valuations on properties are often things that can hold things up. Certainly the cash equivalent transfer values, in particular if they're a public entity that they're through, there's a bit of a backlog with those. So that's the only thing I'd say to prepare if it's for finance. And the only other thing I suppose would be for children's matters, if it's a scenario where there's a likelihood that there may need to be supervised contact in a contact centre, to maybe just have a little research ahead of the meetings as to where they are, what the costs are, whether there's a waiting list, etc.
And as a divorce coach, I often work with people to prepare them for mediation, also in terms of just doing their own thinking about what their top priorities are. what are the things that they can suggest to get these things they really want, and also understanding a little bit what the other person might want, so that they can come with, concrete proposals really to the table.
And Chloe, I know that if a client came from you, I would feel that they're so prepared to actually mediate. That's what can often stall mediations is people. If actually, sorry, that's something that they could research. That's important. In fact, is the legal perspective and the boundaries, legislation around
Yeah.
it. Things like finance. It's under section 25 of the Matrimonial Causes Act, which stipulates what should happen, what the courts expect to happen, what the law states should happen to finances upon separation, and how that differs depending on the length of marriage, etc. So being familiar with that and seeking legal advice are two other things that are important. Often people have a misconception that you either mediate or you litigate, i.e. use solicitors. And that's not the case. Mediators have their role, solicitors have their role. If you have anything to negotiate over, if you want to be supported in a process together to finding a resolution, then you go for mediation. If you want to fight, and that sounds more exciting than it actually is, once you're in that, it's not quite so much fun. It's very expensive, it's very protracted, it's very stressful, it's very damaging, it's very emotional. It's not an arena I'd ever recommend anyone moving into, and it takes away your control as well. In mediation, you retain the control of any decisions. When I say you, I don't mean you as an individual, I mean you as a couple working together to find that is fair and reasonable to both. And I always say to clients, if you went skipping out of my mediation room, even if it's a virtual mediation room, then I haven't done my job very well, because it clearly isn't balanced. It isn't a fair and outcome. If, however, you walk out with a bit of a skip in your step and feeling a little bit kind of like, it's reasonable, I can manage it, then it's usually a good outcome.
I agree. And I completely agree with your point around leveraging lawyers to understand what your standing is. I find that it makes a big difference for people to have the right expectations of what would happen if it did go to court. It helps kind of get people a bit more focused on what's likely and reasonable to request. And so that allows them to develop their own proposals in a much more reasonable manner. So I absolutely agree.
I think what a lot of people don't realize is that the court is such a long process, and you go to court to ask a judge to make a decision, or ask magistrates to make a decision on what you should do with your finances and your children, which to me,
your life,
it's your stuff, and it's a roll of a dice. It depends who you have on what day and the mood that they're in on that day, and the order that you get from one day to the next, even with the same judge, won't necessarily be the same outcome. So it's a risk, and it's a big risk to take. And often people get embroiled in wanting their day in court, particularly if they started the process, they want to continue that route. But I can tell you that there are very, very, very few people that I've met who have come out of court and said, I got a really good outcome.
Yeah, I agree. Completely agree. And so what happens actually on that note, when people reach a deadlock and you realize that there's no, mediated resolution possible there, what are their options, and what do you do at that stage?
What I do at that stage, Chloe, is usually call them out on it and say, we're stuck. I can't move you. I can't make a decision for you. You either work out a different way, go back and get creative with your options. Here are things that you can consider. Why don't you just go away, have a think? What about this? What about this? What about this? Move all those jigsaw pieces around, get creative with a potential outcome, and hopefully come back understanding that actually, if you can't agree on this final point, you're going to court. And what the outcome of that is, unless you know something more than I know, you're not going to know what the outcome is until the outcome is ordered, and then you're stuck by it. So I think we mentioned when we were chatting before about BATNA and WATNA. So the best alternative to a negotiated decision, and the worst. So considering what the best and worst scenarios are. And I'll often say to clients, because I think it's important that they think through, there's no point me saying this is what will happen, and I don't have a role to do that either. But to play things out, what do you think a court would say? I had 2 clients earlier, and there's a dispute around whether or not part of the pension should be ring fenced. And I said, what do you think a court would do with it? And they said, well, I don't know. And I said, well, Section 25 of the Matrimonial Causes Act tells you what they'll do.
Yeah.
So refer to it.
Yeah. Or
Certain
ask
things
your solicitor.
yeah, there's certain things you can find out, but don't just go, oh, we've hit a wall, so let's go to court. There's different ways to resolve it. And I think provided you've got a good mediator who works with the clients, who gives them time, gives them ideas and different ways to maybe consider how they can resolve things, that it's a rarity that people walk away without a resolution unless they literally come into the process without any intention of finding that and wanting a fight. And I can't
That
help
must
those.
happen. Yeah.
It happens, of course it happens. And I used to think it's a reflection on my practice. And now I just go, it's a reflection on the 2 of you. I can't make those decisions.
Yeah.
You need to hear me, you need to play out those options. You need to work out whether it's a realistic proposal, reality test everything, consider everything, make sure you're thinking about the now, the next, the future, all of those things. And I think once you do that and you can get people to really think and be with you in that moment of considering what the options are, most people realize that they can find that solution. Of course they can. They're the best
Yeah,
people.
a lot of times it's about thinking creatively. People seem to think that it's only one person's option or the other person's option, and there's a lot of shades of gray between the two. And so trying to think about other midway points where they can both agree and feel fairly comfortable, that'll be a key to unlocking things.
And that's my favorite bit about my job, Chloe. I think I said to you before, I love being able to get creative. I love actually
Yeah,
seeing the light bulb on with clients when you say, well, what about if you did this, or have you thought about that?
yeah,
For even today there was it was £65,000 that wanted to be ring fenced in a pension, and it was either, well, it's ring fenced and you don't, and we don't share it, or we share it.
yeah,
And I was like, that's not like, and one of the clients threw their hands up in the air and said, well, just ring fence it, then I just want an agreement. I said, well, I can't write up an agreement based on, well, let's just, because I can clearly see it's not
yeah,
okay with you, but you're frustrated and upset. But it isn't just the 65 ring fenced or it's shared 50-50. Like, why don't you ring fence half of it? Why don't you ring fence 60% of it, 70% of it? Do whatever you want with it, offset it to the property, work
yeah,
a way that works for the 2 of you. It isn't just this or this. In between
exactly.
this, there's all of that area to be explored. That's the best
I
bit.
agree.
And I don't like boundaries. I like to be able to explore everything and all the options to find a solution.
And they should all be on the table. I
All of the
agree.
I compare it to, I say to them, if you imagine that you filled up a big toy box with bricks of all of your issues, even if some of them are stuck together and you think there's a solution, I want you to come into the mediation room and tip that box out on the table. Everything is there to be played. And I love an analogy, because it gives people a vision, and then
Yeah,
you can
I agree.
expand it, tip it all out, work out where it goes, or imagine it's a big box of jigsaw, all in a muddle, tip it out, put the bits in where they need to go and work it through. And I guess
Yeah.
that's fun, imagining that you're doing that, negotiating over pension figures.
Yeah, I agree. So in the vast majority of cases where people do find an agreement and reach an agreement, what do you do at that stage? What's the next step of the process?
Again, depending on the clients, depending on whether it's children, whether it's finance, whether it's all issues. So children's cases, sometimes the clients are just happy to go away with the agreements that they've made in the mediation room, and more often than not, that's the outcome. Some people want a parenting agreement, and that's an agreement made between themselves. We would draft that for them. It would
Yeah.
not be legally binding. To be legally binding, it would need to be sealed, signed off by the courts. And they can do that, but I won't go into that right now, but it's not often the right choice, even though sometimes people are like, oh, I want it legally binding for this reason,
Yeah.
that reason. But it does move you very quickly into a different arena, and it makes it difficult to maybe be a bit more amenable with that plan as things change.
Yeah.
So they can have a parenting agreement that's an agreement between themselves that they've both made and worked hard to work through, which hopefully would be sufficient to move forwards. If they need a legally binding agreement, then they can go to a solicitor and ask the solicitor to write an order by consent. So both parties consent to the order and what's in it, and that goes to the court, it gets signed off and it becomes a consent order, which is legally binding. With regards to finance, when they've reached an agreement, there's a couple of options. They can take their agreement to their respective solicitors and ask their solicitors to iron out the finer points and kind of then draft a consent order.
Yeah.
I think you have to be careful when you say you just give it to solicitors and they just do this, because actually the back and forth of checking this, that, the other, and stirring maybe the pot, muddying the waters a little, can often lead you straight back into undoing all of the work that you've done. So what is normally a better option is for the mediator to draft 2 documents. One would be open financial statement, which provides information on the current situation of the finances, exactly as they currently held, how they're legally held, whose name, etc. And that's an open, able to be put before the court if necessary. Along with that, they would have what's known as a memorandum of understanding or a summary of proposals. And basically outlines what's going to happen with each and every asset and liability, how, when, where, what, and why. That's a closed document, so it can't be shared with the courts, and it also can't be enforced in law until or unless it is drafted into a consent order. So at that point, you would take your order. So you jump over the back and forth of solicitors' letters, because you've the agreement's drafted, the information's there. You hand it to one solicitor, instruct them to draft it into a consent order, and then the consent order goes to the courts, and the courts should sign it off. But obviously it has to be deemed to be within the legal parameters and to provide a fair and reasonable outcome for the clients.
Great. Well, this is really helpful. Thank you so much, Katy. It really brings it to life in terms of what the experience is like. I like to end my podcast by asking my guests for their top 3 tips. So I guess in your scenario, if someone is thinking of leveraging family mediation for their divorce, what would be your top 3 tips?
Top 3 tips. I feel like we've probably touched on all of these already. Top 3 tips. 1, be prepared to negotiate. And if you're stuck with that, then go and see Chloe before you come to see me. And she can prepare you. It's a great top tip, right? Yeah, be prepared to negotiate, think through, and a part of that is thinking through best and worst case scenarios for every option, getting creative, imagining you've got that jigsaw or that big box of Lego and how you're going to put all those pieces together, being as creative as you possibly can. The second is, familiarize yourself with the legal parameters, whether that's through research yourself, being careful not to interpret things like Section 25 in your own way, which I have had a client do very recently. I was like, that's a very unusual interpretation of Section 25. But yeah, seek legal advice. There's a lot of places that offer 30 minutes free, some better than others. You can go to a Mackenzie friend, or just make sure you use a good one, recommended one. You can go and speak to a financial advisor. Gain the information, because you can't negotiate if you don't know what there is to negotiate around. So gain the information and understand the boundaries and limitations as per the legislation and the expectations of the courts. That's kind of 3 tips, but one more. Let's think. If it's a child case, or if it's an all issues case, then 100% you need to make sure you bear in mind and keep thinking about what's in the child's best interest, not just from your perspective, but from the child's perspective. What's right for them, and remembering that they have a right to having meaningful time with 2 parents in their lives. And we need the children thrive when they have that, whether they're parents together. But yes, bear in mind the needs of the child. And if the child is old enough, then bear in mind working away to be able to find the child's voice and hear the child's voice. And
I
listen.
think that's a very good one, a very important one. That, you know, the voice of the child is so important, even if it doesn't mean, you know, it doesn't mean that the child is making the decisions,
Right.
but just the fact that they're being heard, that they're being consulted. It's so important psychologically for these children that often feel like they're kind of caught in the middle of it all, and for the parents to keep that in mind and to really think from their perspective.
And that's a whole nother conversation, right? About child inclusive
It probably
engagement
is.
and child's voice. But just on that note, one of the things that we do often hit is that worry for parents that you're asking the child to make a choice. When in child inclusive mediation, we'd never be asking a child to make a choice. We'll be asking a child to tell us and share with us about their wishes and feelings and what their hopes are for the future and what they would like from life. And then hearing all that and sharing it with the parents for them to hear exactly what it is that's important to the child in case it's got lost, which it often does. But it isn't burdening the child. Some people go, I don't want to bring the children into this process. They're already caught up enough. That's one way to look at it. And again, you need to look at it from a different perspective. What it's actually telling the child is we care about your voice. We care about your views. We want to try and work out what's going to work for you as well as for us. And this is important, and it can be incredibly empowering for a child to be able to have that option to have their voice heard, but more so in child inclusive mediation, it's a completely confidential process. So if the child wishes to attend and speak to a mediator, usually a lovely, friendly, child-friendly mediator, if they decide that they've had a lovely chat and they've offloaded some of their stress and their worries in a safe, secret place, then but if they want to relay anything to their parents, then there needs to be permission, obviously with the exception of safeguarding, but otherwise it's a safe space. It's an opportunity for them to have a little kind of mini therapy session, I guess, and just offload, no judgment, with no worries about it being shared elsewhere, usually in a neutral place, so at school, supported by school staff, etc. But it's a big topic, that one, Chloe, a big topic.
I recorded another podcast in the past on that topic, and it's a very interesting one. But as you say, it probably needs its own
We'll be here for days.
But I love your 3 tips. So just to summarize, the first one is coming in with the right mindset and being willing to negotiate and to put things on the table. The second one is getting the right professional support, including legal support. And then the last one is keeping the kids at the center of your considerations. They're all brilliant tips. Thank you so much, Katy. It's been great chatting to you. Thank you for all your insights and all the information you shared.
Thank you. Thank you so much for having me. It's been lovely to chat with you as always, Chloe.
Take care, Katy.
Thank you.